news. Have you checked out the form N400 application for naturalization? Did you also check out the instruction form that goes along with the form N400 application for naturalization? Let's talk about those great news. My name is Bijoux Ngwanda, as you know it. I am an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing every day with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also follow me on all platforms. Links are in the description box below. Let's get right into the subject, my friend. If you got your green card based on VAWA, meaning what? Meaning that the green card was issued to you based on the form I-360 and you were abused or battered by your spouse, who's a U.S. citizen or lawful permanent resident, or you are a parent of a U.S. citizen who suffered extreme cruelty like abuse, and or you are a child of a U.S. citizen or a lawful permanent resident who also got their green card based on VAWA, basically based on abuse, then you are eligible to file for U.S. citizenship after 3 years of your residency, okay? What are you gonna do? You're gonna look at your green card and look at the date the green card was issued and count 3 years. If 3 years is today, then today you are eligible to apply for your U.S. citizenship. My friend, you can schedule your consultation by using the consultation link in the description box below. That's the first category, okay? Then the second category of people, those are the people who got their green card based on VAWA cancellation. Remember that in court, there's another type of relief that you seek in court when you're trying to cancel your removal proceedings based on VAWA, based on being abused. And if you got your green card based on VAWA cancellation, then you too, you are eligible to apply for U.S. citizenship after 3 years, okay? Then what are you gonna do? Again, you look at your green card, the date the green card was issued, and if 3 years is today, my friend, go ahead and schedule your consultation because you are eligible to apply for U.S. citizenship, okay? And then the third category, this is for people who remove their conditions. Remember, like in order to remove a condition on your green card, you have to file the form I-751. And if you file that form I-751 based on a waiver of abuse and it was approved, you are also eligible to get your green card, to get your U.S. citizenship. I'm still on that green card. To get your U.S. citizenship, basically to apply for it after 3 years of your residencies. For you, you're gonna go and look at the date you receive your conditional green card, and if it's 3 years already and your I-751 based on approved abuse, if it was approved based on abuse, now you can also apply for U.S. citizenship, again provided that you meet all other requirements of good moral and character, because that's the big one, and you know, and you're 18 years and older, and you meet the continuous residence presence, physical presence in the United States. According to this new instruction, at least 18 months of physical presence in the United States within that 3 years period of time, then you can apply for your U.S. citizenship. This is a great news, really. It's really great news. It's cutting off people from waiting for 2 years again. If you already met the 3 years requirement, then you don't have to wait for another 2 years, especially for people who have to bring their family member on the family-based category. Remember, if you are a U.S. citizen, then it goes, the I-130 get approved much quicker than the lawful permanent resident. And the U.S. citizen, of course, for the purpose of waiver. You can again be qualified as immediate relative, or for the purpose of adjusting status with another spouse. This is really great news, right? So if you need a consultation with me, my friend, you can schedule it by using the consultation link in the description box below. Also, there's another great news where USCIS has clarified, okay? They did that. They did clarify when it comes to EB3, they did clarify the terms science and art. And specifically, this is good. Why? Because under Schedule A, if you don't know it, let me just talk a little bit about it. Under Schedule A, or under employment-based in general, what goes on with employment-based type of petitions is that the employer has to file for a labor certification first, right? Once it is approved, then the employer will file the form I-140 combined with the approved labor certification to USCIS. And undergoing the labor certification process, it's really burdensome for employers. That's why some employers are not willing to petition for other people, because it's just too much to ask them, okay? But under Schedule A, what's going on is that the Department of Labor has already pre-qualified those people as basically they meet the requirement. Basically, shortage is in this type of employment. For example, therapists, nurses, they're already pre-qualified. So you can use the blank labor certification and the I-140 without undergoing labor certification with the Department of Labor. And the employer can petition for you directly with USCIS because you're already pre-qualified. So now what is new? What is new is that they added on the Schedule A, Group 2, they added art and science, and they did clarify that too. Really, it's basically, in summary, it's basically they go with the definition under the Labor Department, meaning that any college degree that somebody will get that offers specialized courses for that degree, that is science, okay? You have to have been receiving specialized courses for that degree under science category. If you really want to know whether your degree is considered science for the purpose of waiving labor certification, so that the employer can petition for you, again, schedule a consultation by using the consultation link in the description box below. Until next time, bye-bye.